Hello and welcome to the big picture. The fate of the 1993 Mumbai blast convict Yakub Menon hangs by a thread. A three-judge bench of the Supreme Court today have rejected his petition challenging the curative petition decision on the curative petition. So now the question is, what next? He has today, this morning, filed another mercy petition. In fact, with the second mercy petition, the first one was filed by his brother, which had been rejected by the president earlier. So this fresh mercy petition is before the president right now. We are told that the Home Ministry is seized of the matter. Meanwhile, the only way out for Yakub Menon to survive is if the president decides to go against his own decision which he had taken earlier. So can this be possible, or is Yakub Menon's fate almost sealed? We will discuss all this today with P.P. Rao, a senior advocate in the Supreme Court, Kirti Singh, a former member of the Law Commission and also a senior advocate. We will be joined by Mr. K.T.S. Tulsi, a Rajya Sabha MP and a senior advocate. And in the studio with me is Satya Prakash, legal editor of the Hindustan Times. Welcome to all of you. Mr. Rao, you know, what is the situation now? All the avenues which were there, almost all the avenues which are there as far as Yakub Menon is concerned, has been closed. So now this mercy petition which he has filed this morning with the President of India, apparently it is there before the Home Ministry now. What will happen now? How will things shape up now? Kirti Singh, I think we have lost his audio line there. Kirti Singh, if you have heard my question, can you please answer that?
Consider the mercy petition and, as you said, most likely reject it. But I must say that this is a sad day for Indian democracy, because there were substantial points which were raised in front of the Supreme Court, and particularly the fact that he had already spent 20 years in jail. And while this was considered a mitigating circumstance for the other 10 people who were let off with life imprisonment, this particular prisoner had to be sentenced to death. Secondly, the way in which the Supreme Court interpreted his role, I respectfully disagree with that, because I feel that the real planners were the two, Tiger Menon and Dawood Ibrahim, and Yakub was obviously a smaller actor. And even the people who had planted the bombs, who had gone for training to Pakistan, who were earlier sentenced to death, were let off by the Supreme Court as being, not masterminds. But Yakub was, I think, a little erroneously held to be the mastermind, though in the absence of his brother and Dawood Ibrahim.
Okay.
So thirdly, I feel that the jail doctor who had certified that he was mentally unfit, he had schizophrenia, needed to be heeded to. And I don't know what kind of certificate he's got today. It was reported that it was the jailer who had said that he's fit to be hanged, but I don't see how a person who has schizophrenia can be fit to be hanged. And there have been umpteen precedents which have held that schizophrenia is a mental disease, and a mental person who's suffering from a mental disease should not be hanged. This is all apart from the fact that a lot of us do not agree with the death sentence at all, because of the manner in which investigation is done in this country, the kind of prejudices that exist.
Kirti Singh, I'll come back to you. I think, as far as the issue of death penalty is concerned, is a separate issue, a larger issue, sure, which needs a further debate. But let me get Mr. Tulsi in on this. Mr. Tulsi, So Tulsi, I think two issues were taken up by the Supreme Court today. One is about the curative petition, the second about the death warrant itself. And both have been rejected by the Supreme Court. So, how do you look at this decision?
That's right. Well, I think the Supreme Court decision is on expected lines, because right at the last minute, if you keep on raising new points without there being any substance in it, then the Supreme Court cannot dilly-dally, because the Supreme Court has a dual function. It has to balance the interest of the society and the interest of the victim on one side, and the interest of the accused or the rights of the accused on the other. And once the matter has been, the appeal has been considered at length, evidence weighed, and then review petition also dismissed, after that, the curative, the only question with regard to curative was as to whether the correct the quorum was there or not. Now the quorum is for the Chief Justice of India to decide. And they proceed, who are the judges? The requirement of judges who decided the review petition to be included in the bench on curative is not borne out from any rule that we are aware of. If Justice Kurian Joseph did mention it in his order, there may be some practice which the judges are aware of and we are not. But if once the three judges today have reviewed that question, and they find that it is the prerogative of the Chief Justice of India, and he has to constitute the bench on the basis of which of the judges are conveniently available. And if he has decided there is nothing wrong, there is no breach of the rule or the breach of the rule of natural justice, and the matter has been considered, there were no grounds which can be said to have been ignored by the curative bench, and therefore they have found that the disposal of the curative petition was in order. Once that is done, then the death warrant also, then there is no defect in the issuance of the death warrant. You see, in this case, the mercy petition had been rejected several years ago, and therefore the notice that is required to be given of 7 days in a judgment, that does not apply to the facts of this case. I think that moment these procedural hurdles were cleared, there was no other reason. The only other reason that was mentioned was that Mr. Raman's article which appeared in the newspapers, but one doesn't know. The Attorney General was quite forthright and conclusive in his submission that there was no such promise that was made. Once the Attorney General makes that kind of a statement, there is nothing further left for the court to decide. And I think that is how the decision turned.
Okay, there was nothing left for the court to decide. Satyaprakash, would you agree with that?
Yeah, so far as the court is concerned, there was nothing left because the two issues were raised. Mainly one, that curative bench was not properly constituted.
Right.
So once the court comes to the conclusion that that was properly constituted and there is no infirmity in the death warrant,
What were the issues as far as the death warrant was concerned?
Death warrant, what he said was, death warrant was issued before he could exhaust all his legal remedies,
yes.
before he could file his security petition. But then, death warrant, his mercy plea review petition was dismissed last year, in 2013 itself, and then mercy petition was dismissed by the President in April last year. And thereafter, this 14-day requirement of 14-day period for execution from the date of mercy petition. So mercy petition was dismissed last year in April, and since then not 14 months have elapsed.
No, but what about the fresh mercy petition today?
That is the only issue to be considered. The governor has dismissed the mercy petition.
Let me get this a little straight. What is the law or what is the procedure? That 14 days after the last hurdle is passed, that death warrant can be implemented. Is that the procedure?
Last year, Supreme Court passed and issued a judgment in which it said there has to be a 14-day gap between the dismissal of mercy petition and actual execution. In this case, so far as the Supreme Court is concerned, it has said that this does not apply. Why? Because so many months have elapsed, and he did not challenge the rejection of the mercy petition. But this fresh mercy petition filed before the governor and today before the President,
right,
he must have raised certain new grounds. The only question to be determined is whether the 14-day period should be counted from the rejection of first mercy petition or the second one.
Okay, I think that's an important point. Kirti Singh, is that an issue which will be taken into consideration at all? I mean, time is running out very fast.
Yes, yes. That's an issue that can be taken into consideration, I think, because if there's a fresh mercy petition and the president decides that, then, I think in all reasonable this thing, the 14 days time should be given. What is the great hurry? The man has been in jail for 20 years, you know.
Okay.
And if Ramanna's evidence has not to be taken into account, I mean on the saying of the AG, then there are at least 6 Supreme Court judges who were party to the mercy petition, which was in front of the President, you know.
Okay. Okay, Mr. Tulsi. Yeah, yes.
And I don't think that has been rejected.
What former raw official said, it's not an evidence.
It's not evidence.
It's not an evidence that
if he was alive and if he had presented an affidavit himself,
maybe it's a revelation, but it's not an
evidence which the court can take notice of at this stage. Mr. Tulsi, what happens to the present mercy petition before the president, which we are told is under active consideration of the Home Ministry? Now that 14-day period which the Supreme Court itself had ruled last year, what happens to that? Is that going to be applied in this case, or the first mercy petition which was rejected will be taken as the time?
You see, it can't be applied in this case. If you start applying 14 days period from the date of every rejection of mercy petition, then nobody will ever be executed. Because moment one is rejected, there will be another one filed. When that is rejected, another one will be filed. So the 7 days period, 15 days period was prescribed by the Supreme Court in the case of Afzal Guru, because there the family was not informed at all about the date and time of execution. And their right to be able to meet the member of the family who was going to be executed was deprived. The dead body could not be delivered to them. So that was the context in which this period of 2 weeks was laid down. In this case, when there has been a mercy petition which was decided over a year ago, after that review petition is decided, then the curative is decided. How do you say, let us assume that today at 8 o'clock the President rejects the mercy petition. And do we have to count 15 days from this date?
That is the question I'm asking. Do we have to?
Date, and on the 14th day, another mercy petition is filed.
Sir, Mr. Tulsi,
it can't be done.
No, Mr. Tulsi, I have a fundamental
period of.
Mr. Tulsi, I have a fundamental question here. How many mercy petitions can be filed? Is there any limit to those mercy petitions which can be filed?
See, No. The Constitution only talks about a mercy petition. But in reality, multiple mercy petitions are filed. They are filed in this country, they are filed in all countries. And the question really is that the only requirement is before the time of execution, mercy petition must be disposed of. Because moment mercy petition is received in the office of the governor or in the office of the president, immediately a message is sent, a telegraphic message or by fax or whatever, electronic means, a message is sent to the jail and to the court that mercy petition has been received and no execution will take place till it is decided. And so therefore, the execution gets stayed.
So as of now,
the question really is that if after multiple mercy petitions, as of now, the execution can't take place till the President decides the mercy petition.
Okay, I think we have got Mr. P.P. Rao back. Mr. Rao, can you hear me?
Yes.
Okay, Mr. Rao, the key question now is this, that there is a mercy petition pending before the president now, a fresh mercy petition filed this morning by the convict himself. The earlier one was filed by his brother, which had been rejected. Now this mercy petition, if it is, there are two questions which I have for you. One is, if this mercy petition is decided either way, that 14-day period which the Supreme Court itself had mandated earlier, will that apply to the fresh decision which is going to be taken today, tomorrow, whenever? And second question, is the president bound by the advice of the Home Ministry on this matter?
Yes. First question. Already one mercy petition has been filed on his behalf.
By his brother?
And that has been rejected.
Right.
Brother, whoever has filed it, and that if that mercy petition covered him as well, then the question of again 14 days commencing today will not arise. Number one. Second thing, which I mentioned is that about this, the second petition, and that is to be decided by the president, and then whether he is bound by the council minister's advice. Yes, the rule is this: he is bound in the execution of his office by the advice of the council of ministers, but he has got one option. If he doesn't agree with the advice, he can send it back to the council of ministers with the reasons for reconsidering it. And for reconsideration, if the council of ministers advises him to act in a particular manner, he has to act in that manner. So that is a constitutional mandate.
Okay, so that means that he has won. The president has one chance to return it to the council of ministers or to the home ministry, and then whatever advice is given, second time he has no option but to just follow what the advice is. Is that what you are saying, sir?
That is what the Constitution says.
Okay, that's what the Constitution says. I think we are now joined on the phone line by Mr. A.S. Dulat, the former Raw Chief. Mr. Dulat, how do you look at this, at what has happened today in the Supreme Court?
You see, I'm in Chandigarh. I really don't know, but I've been told that the Supreme Court has decided that he must hang.
Right.
Now, I can only say that...
No, they have not decided he must hang, but they have said, they have dismissed the curative petition, and they have said that the death warrant issued is perfectly in order. And now, since a mercy petition is pending before the president, whatever the decision comes from the president, after that, whatever has to happen will happen. But the Supreme Court has rejected the curative petition as well as the questions raised about the death warrant.
Yeah. Well, if the mercy petition is still pending before the president, I guess there's still some hope for Yakub Menon. But, I just feel that hanging him would be a terrible waste. And it's a pity that nobody has taken note of what Mr. Raman wrote in his letter.
Right.
Or the letter that Justice Harjit Singh Bedi, a retired Supreme Court judge, which appeared in the Express.
Yes.
In which he also pleaded for mercy for Yakub.
Right.
You see, what happens in these cases is that nothing happened just now. But it leaves a scar in the psyche of certain people.
Okay. No, what are the consequences of what has happened now as far as the intelligence agencies are concerned, according to you, in future?
See, it's very difficult for me to say what the consequences will be. But when it affects people's psyche, then you never know what the consequences will be. If as I say, I don't think anything will happen immediately. But in the future, somewhere, something could happen. When Afzal Guru was hanged, I had the same view that I thought it was a terrible waste. It served no purpose.
Okay.
And I think this hanging also will serve no great purpose.
Okay. Mr. P.P. Rao, I'll come to you, Kirti Singh, also. Mr. P.P. Rao, apparently there is a precedent where a president of India had rejected a mercy petition, and which was Dr. Shankar Dayal Sharma, and then later on the plea of many citizens, of many eminent citizens, he reversed that order. You know, you think that something like that is in the hands of the president, but as you said earlier, he has no role to play as far as this is concerned, except to send it back once. But you know, when this happened in 1997, yes, when Dr. Shankar Dayal Sharma overturned his own order and then gave, you know,
yes,
brought down the death sentence to life imprisonment, is that something like that possible here?
Yes. No, even now, if the president is of the opinion that the cabinet advice is not ready to be accepted readily, and he can send it back to the cabinet and giving the reasons why he is sending it back and why he wants the cabinet to reconsider the matter. But the Constitution says second time the advice is given, he has to abide by that. So that's how the Constitution stands. But the question is, another question to be considered is,
yes,
are there any new grounds now which have been incorporated in the mercy petition, which were not urged at all earlier?
Okay.
That's an important point to be seen. If there is some new material which has come now on record, which has a bearing on the mercy petition and on the exercise of the power, then that will be a consideration to take into account, even for the government and also for the president.
For the president.
And also it is expected that a popular government will certainly consider the views represented by so many people, eminent people who have made a representation appeal to the president to exercise the power of mercy. That the popular government is expected to consider all this and then give an advice.
Okay.
But coming to the question which Mr. Dhulat has now mentioned, I want to make one comment about it.
Yes.
That is the futility of hanging. I think there is something terribly wrong with our criminal justice system. It takes so many years for the accused to be under the shadow of death, which is a death every day. So this is a human aspect which has to be considered. But now we are at a stage when all the other legal remedies have been exhausted. And we are at the last lap now.
Absolutely, at the last lap now. Kirti Singh, you think that any new material which has been added in the latest mercy petition, you think that there is any scope for it? Because I know as far as the public is concerned, whatever is available in the public domain, except that B. Raman's letter or B. Raman's article, there is nothing new which has emerged in the last few days.
Yes, except that the president can consider a lot of points that were raised by eminent citizens and activists and former judges of the Supreme Court in their mercy petition, which is pending before him also. And there were points, one of the points was that Yakub Menon is an important witness because he had surrendered to the police after some understanding, and if he is not there, then there is no other witness available.
Okay.
The other thing was that all the points that they raised about his illness, about all the other cases
okay.
in which death sentence has been commuted to life sentence, in in Veerappan's
today in fact, today, Kirti Singh, today in fact,
killers, and in
yeah, we are running out of time, but today, yes, in fact, the Rajiv Gandhi's three convicts in the Rajiv Gandhi's assassination case who were sentenced to death have been commuted to life just today by the Supreme Court itself. That's a very interesting thing. Mr. Tulsi,
yes,
you heard Mr. P.P. Yes. Rao. You think that any such considerations can be taken into account at this point of time?
You see, one of the grounds in the mercy petition which was filed recently, or maybe this morning, I don't know, perhaps is that there was a promise made to him by a certain intelligence officers that if he cooperates and if he gives them the evidence against Pakistan and how they are running the training camps and in the manner in which the modus operandi in carrying out these attacks, even the subsequent attack on Mumbai when Yakub was perhaps in Pakistan. And in response to that promise, he actually gave us evidence on the basis of which we were able to get Pakistan declared a terrorist state
but
from the United Nations, by the United States of America, and
no,
other
Mr. Tulsi,
countries.
sorry
If
to
he has
intervene,
kept
but
his part of the promise,
Mr. Tulsi, what
if he has kept...
is it new evidence? That's the question. The question is whether it is new evidence.
Yes, because nobody has brought it forth before.
No, it's a new evidence because
it is new
no one
evidence.
else had
Nobody
perhaps
has
pleaded. I
considered
don't
it
know.
before.
Okay.
I don't know these documents. But if it is new, it can be taken into account and the official file can be summoned by the President.
Okay, okay. Satyaprakash, very quickly, now that the matter is apparently before the Home Ministry, and has any case in the past been decided in such speed, in one day? You know, so many things happen.
No, it's one day it can be decided because there is no time limit fixed. The only last year the Supreme Court, there were petitions that the government is or president is taking too much time in deciding mercy petitions. The court did not fix a time frame. It said that it has to be done. But what is important is the entire process of mercy petition and the power of pardon. In the ultimate analysis, it establishes the supremacy of the political system, political class. It is the politicians who take the last call. That's a different thing that ultimately that is subject to judicial review. But this decision is a political decision. Whether to hang him or not. It's a political decision, and the president has to abide by the advice of the cabinet.
I think on that note, we need to. It's going to be a political decision. It can come any time now. There is the Home Ministry, the Rashtrapati Bhavan, all seized with the matter. We'll have to wait and watch what will be the final decision. Thanks to all my guests. We'll wait and watch what will happen. Please keep watching. We'll come back with another issue on the Big Picture same time tomorrow.